Hi, good morning, Joe.
Good morning, Ms. Clerk. How are you?
I'm good. How are you?
Well, doing pretty well, thank you.
You do have one case this morning. Do you want his name and case number?
Yes, please.
Eric Espino,
Okay. Eric.
RPC 2025-064534.
Okay. Now, is there a complaint that I need to translate for this
Nope,
defendant?
not
No.
yet. It's just a
Okay.
bill hearing today.
Okay. All right. Thank you so much. I'll be ready to go.
You're all right. We are just waiting for the jail and the DA.
Okay. Sounds good. Thank you, Ms. Clerk.
All right, you are good.
Morning, are we ready to proceed?
We are, Your Honor.
Good morning, Your Honor. The state's ready to proceed as well. Thank you. Good morning. We're here today for the in-custody arraignment calendar. Today is Tuesday, November 11th. Before we begin, are there any requests for continuances or special requests regarding the order of proceedings? We will be calling the interpreter matter first, followed by Mr. Balding's case.
Thank you, Your Honor. Your Honor, we have waivers, but no continuances. So I'll make that argument when they come up. Therefore, no special order.
Thank you. Just to confirm, waiver of appearances.
Yes, Your Honor.
Thank you. State?
Thank you, Your Honor. So I'm just checking. It looks like the state will be requesting a continuance for victim contact on one case, that being Mr. Eric Espino.
Thank you. We'll go ahead and begin with Eric Espino, followed by Travis Balding, or Blading.
Señor Eric Espino.
Okay. Okay.
Sorry.
Excuse me.
Try it.
Good morning.
Buenos
Court
días, señor.
indulgence, please, a moment.
Just like the one.
Thank you. Good morning.
Buenos días, señor.
We're here today for
Good
first
morning.
appearance bail hearing.
Ahora vamos a considerar el asunto de la fianza.
Probable cause has been found and the public defender's office has been appointed to represent the defendant.
Hay causa fundada para su arresto y también se le ha nombrado un abogado defensor.
Just for the record, the defendant is present utilizing the services of a previously sworn and certified Spanish interpreter.
Y para el acta, el señor está presente como el señor acusado utilizando el servicio de un intérprete bajo juramento en el tribunal.
State, what is your request?
Ahora, ¿qué dice la señora fiscal?
Thank you, Your Honor. The state's requesting a one-day continuance for victim contact.
Gracias, su señoría. Lo que queremos hacer es posponer el caso un día más para que podamos comunicarnos con la víctima en este caso.
We left a message for the victim this morning and are waiting to hear back from her.
Le hemos dejado a la víctima un mensaje esta mañana y nomás estamos esperando de que nos regrese la llamada.
Thank you. And state, just for the record, the court has information that there is a pending case in terms of there is a criminal complaint that has been filed against this defendant with the same named victim. He has not been arrested on that case yet. Do you believe that we would be able to proceed with all cases tomorrow?
Parece que tenemos información sobre este mismo acusado con la misma víctima también otro caso criminal. ¿Qué información tendrá sobre eso?
Thank you, Your Honor. So I do see another case with a separate Reno Police Department case number in our system.
Sí, su señoría. De hecho, veo otro caso también pendiente en nuestro sistema aquí con la policía de Reno.
We haven't received reports for that case yet, but I would expect that we'll receive them from pretrial today.
Todavía no tenemos ningún informe sobre el otro caso aparte, pero supongo que hoy día nos llegarán los informes.
Thank you. Defense?
Gracias,
Thank-
señora defensor.
Thank you, Your Honor. Your Honor, I believe under Marcy's law and the ideals thereof, I don't have a basis not to, or to object to the continuance of one day.
De acuerdo, su señoría, de acuerdo con la ley Marcy, no creo que hay protestas, tenemos que posponer un día.
Thank you. The court does find that there is good cause to grant a continuance.
Gracias, la jueza halla de que hay causa para posponer un día más el caso.
On the basis of Marcy's law and the constitutional rights associated with the named victim in this case.
Y esto estará de acuerdo con la ley Marcy's y también de acuerdo con los derechos constitucionales que tiene la víctima en este caso.
We are still within the 24 or the 48-hour time period if we continue this for tomorrow.
Y si lo posponemos para mañana, todavía estaremos dentro de los derechos de atender el caso dentro de 48 horas.
So, sir, your bail hearing will be continued until tomorrow at 9:30 a.m.
Así que, señor, eso es todo por el momento, pero mañana a las 9:30 AM vamos a considerar el asunto de la fianza en el caso suyo.
Thank you.
Gracias.
You understand?
Yeah, I understand.
Next, we have Travis Blanding, followed by Trent Fast.
One moment, I'm so sorry, Your Honor, one moment, please.
I think
Jill, is that the only interpreter matter that you guys have?
Ms. Clerk, I believe it is. That's what
I'm
I
just-
understood.
Yes, I'm just confirming with the Jill.
Okay.
That is the only interpreter matter, Your Honor. Thank you.
Thank you.
Thank you, Jill.
You're welcome.
Yeah.
Oh, that was with me.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has not yet been appointed to represent you, as you indicated that you would retain private counsel. Sir, have you hired an attorney to represent you?
No, ma'am.
Thank you. So I can determine here today to see if you qualify for the services of the public defender, or I can also continue this to allow you the opportunity to seek private counsel and to hire an attorney. How would you like to proceed?
I told the lady up front I won't be able to pay. Cause I wouldn't know, cause I don't know if I would like have a job or not. Like right now, I don't have a job, so.
Your Honor, I would ask, based on my conversation today, for the questions to be asked regarding qualifying under indigency.
Thank you. So based off of that, sir, assuming that you are to remain in custody, how much money are you able to make per week, if any?
A week, maybe 600-700.
And that's to confirm if you are in custody, you are able to make that
Or
amount.
if I'm in custody, no, I won't make nothing if I'm in custody.
Thank you. I do find that you qualify for the services of public defender, so the Washoe County Public Defender's Office will be appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 10 or a higher risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. As Your Honor can see, Ms. James is present today to give a statement to the court. She is the minor named victim's mother. So the state's requesting bail in the amount of $10,000, DAS supervision with testing for drugs and alcohol if he's able to post, and I would request no contact with the victim. As Your Honor noted, he scores a 10 on the risk assessment. He's got an active suspended sentence out of Reno Municipal Court. He has a non-extraditable warrant out of Florida on a domestic charge. He's got a non-extraditable failure to appear warrant out of South Carolina. Already this year, he's got a misdemeanor arrest for violating a domestic violence TPO, 5 counts of that. Miss James is the victim in that case. As Your Honor knows, she's the mom of the victim in this case. He was attempting to contact her while in jail for violating a TPO. We no-issued that case because it was attempts to contact, not successful contacts. Also this year, misdemeanor arrest for violating a domestic violence TPO that was out of Reno Municipal Court that was dismissed without prejudice on the date of the bench trial. 2024, he's got a misdemeanor conviction for resisting, a misdemeanor arrest for domestic battery second out of Reno Municipal Court. Same victim, Miss James, in that case that was dismissed without prejudice on the date of the bench trial. Misdemeanor conviction for DUI out of Reno Municipal Court. He had a post-adjudication warrant issued for failure to comply. Also a misdemeanor arrest for failure to pay or failure to comply. 2022, a misdemeanor conviction for assault and battery out of South Carolina. 2021, a misdemeanor conviction for battery out of Florida. 2011, a felony conviction for burglary second out of South Carolina. 2010, a misdemeanor conviction for domestic violence first out of South Carolina. And 2008, a felony conviction for burglary third out of South Carolina. So obviously, Your Honor, he's already shown this year that he has compliance problems. He doesn't comply with court orders. He also has a lengthy history of violence this year, last year, the year before, and the year before that out of multiple different states. And as I mentioned, he's got non-extraditable warrants out of 2 other states. He's got an active suspended sentence out of Reno Municipal Court. So the state is requesting bail in the amount of $10,000, DAS with testing for drugs and alcohol if he's able to post, and no contact with the victim.
Thank you. Do you have any information as to what that suspended sentence is for in Reno Municipal Court?
So I didn't make a note of that. I think it's the DUI from 2024, but I can go back and look at that, Your Honor.
Thank you. Defense?
Your Honor, it's my understanding, speaking backwards to forwards, that Reno Municipal is on the DUI. Mr. Blanding said it should be finished. And I have not been able to check, but I believe it is just fees left. Working backwards from there, looking at the risk assessment, I would reflect that the state's version of the criminal history is not incorrect, but that criminal history is taken account for in the NPRA, which is the validated study. On that, he scores a 10. 4 of those points come from residency, employment, and cell phone. Our office was able to reach out to Rosemary James. I believe that it is her daughter and not herself that was the alleged victim in this case. Therefore, looking at it and speaking with her, he had been employed. We were also able to reach out to Erin at Bristol. Unfortunately, though she informed us that he was a good employee, their policy of 90 days with daily appearance means that because of this arrest, he was not able to appear. He says that he will be able to get back in with the staffing agency. Miss Rosemary was able to give us his cell phone number and confirm residence. Additionally, he would comply with any CPS or no contact orders. Based on the totality, as well as this case, the alleged injuries being of the fairly minor side as a part of a scuffle between a 17-year-old who had engaged in conduct that I'll let Miss Rosemary describe if she chooses to, and a small scratch to the face. It is my understanding she does not want him held, nor does her daughter feel unsafe, though I'll let her speak to that. And with that score dropping to a 10, based on the information we were able to obtain, I would say that he is a medium risk, and there are less than monetary means, including check-in to ensure safety of the community. On that, I'd submit.
Thank you. Defense, just to confirm, he was a 10 or is a 10 according to the Nevada pretrial risk assessment with the reductions. I believe that would be an 8. Is that correct?
Was 10 with the reduction for former employment as of the date of this arrest, cell phone and residency. That drops it to a 6 because it's 211.
Thank you. Ms. James, the law affords you an opportunity to be heard. If you wish to speak, I'm just going to have you say yes, and then I will swear you in. And I think that you said yes before you unmuted your microphone. Thank you. So I'm going to have you raise your right hand. Do you swear or affirm that the testimony that you shall give today shall be subject to the penalty of perjury according to the laws of the state of Nevada and shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. As the mother of the named victim in this case, you do have an opportunity to be heard here today. The purpose, just to make sure it's clear, the purpose of today's hearing is just to determine whether or not there should be any bail amount assessed in this case. So if there's any concerns for your safety or your safety of your child, the named victim in this case, as well as if there's any conditions that you feel that are necessary and appropriate in order to ensure the safety of the community or his appearance and her safety. Please proceed if you're ready. And I'm just gonna have you start by stating your name and spelling your last name for the record.
Rosemary, last name James, James.
Thank you. And please proceed.
Okay, so basically, I feel like it was real childish. It was just over an Arizona drink. So basically, she licked the Arizona, and then it made him, feel irritated and a little angry. So finally, he went in the room and just locked the door, and then poured it on her. Then she got angry and punched him, and then I just pushed her away. Um, Honestly, I did not see him scratch her, but she was really angry, and I had to, push her away. He didn't attempt to scratch her at all. He's not abusive towards kids, and that's my understanding. God, honest truth.
Thank you. So just to confirm, are you requesting a no contact order on behalf of the named victim in this case?
No, because I don't feel like he's a threat towards my daughter. Just my daughter has anger problems. Like little small things make her angry, in the past, I got her some help for it, like for counseling and medication and stuff. It's hard for her, she just get angry, get angry real quick. I'm still working on that with her.
Thank you. State, do you have any questions for Ms. James?
I do not, Your Honor. Thank you.
Thank you. Defense, do you have any questions for Ms. James?
I do not, Your Honor. Thank you.
Thank you. Thank you so much, Ms. James, for being present here today. I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So I am granting an own recognizance release here today. I will require that the defendant be supervised by the Department of Alternative Sentencing. So, sir, you must check in with the DIS within 24 hours of release. I am imposing the condition that the defendant is to have no unsupervised contact with the minor child with the initials of AM. So just to make sure that is clear, it is to be no unsupervised contact. That will be the order of the court, and we'll go ahead and set an arraignment, which will be set for November 26th at 9 a.m. And just, I did consider the other requests for testing, and I'm not imposing it at this time as I do not find that there's sufficient access. Thank you. So we'll
Thank
see
you.
back here in court on that date and time. Thank you. Thank you, ma'am, again for being present. And that concludes this.
Of course. Of course.
Trent Fast Horse, followed by Vivian Potter. And so, Ms. James, if you would like, you're free to log off.
All right, perfect.
Thank you. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 4 or a low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, thank you, Your Honor. The state's not objecting to an own recognizance release for Mr. Fast Horse with DAS supervision with testing for alcohol and no firearms.
And the basis for the testing?
So in the probable cause declaration, Your Honor, it talks about how there was drinking going on in the car, in the defendant's car. He ran away, but then he ultimately came back.
Thank you. And I saw that. I just didn't see that there's any nexus tying him to the alcohol.
Well, it was his car and he ran away and then came back.
Thank you. Defense?
Thank you, Your Honor. We would stipulate to the OR release with those conditions. We would ask that DAS or testing be considered from the perspective that he does live in Wadsworth. We were able to speak to his mother, Nicole. I believe that there are services out there from other interactions, but it will be challenging to drive back and forth if there's daily testing. With that, we would ask that the court follow the state's recommendation.
Thank you. Based off of the information provided, I do find that there are least restrictive means that can be imposed in order to ensure the safety of the community. So the defendant will be released here today. Sir, I will require that you be supervised by the Department of Alternative Sentencing. So you must check in with the DAS within 24 hours of release. I am imposing the condition that you cannot possess any firearms or weapons. And just for the record, that is due to the nature of the charges. And I find that that is a least restrictive means in order to ensure the safety of the community. I'm not imposing the other conditions requested. I do not find that there's sufficient access. I am requiring that you appear for an arraignment, which will be set for November 26th at 9:30 a.m. Thank you.
Thank
So
you.
you must appear in Reno Justice Court. Thank you.
You can make it out to us.
Vivian Potter, followed by Susan Tyrell.
Potter is unable to appear today in court. I believe we can proceed on her behalf.
Thank you. Unfortunately, I need some additional information. So Ms. Meyer, do you have enough information to determine whether or not she qualifies for the services of a public defender?
She sure does, Your Honor. She, both that is based on the evidence of this case. While she was a tenant, we were able to establish that there has been significant challenges for her making ends meet, including some mental health history that I believe that she is seeking to apply for SSDI, but there is no additional information now about whether she's qualified. And she was, in 2024, she qualified for our services. Based on the totality of that, I think it would be appropriate.
Thank you. Do you have any information as to whether or not she's currently employed?
I believe that she is not, Your Honor. She, at least at this time, we have not been able to find any ability to find a working place. We spoke with her grandmother, and it is my understanding at that time that she was not working and struggling to make ends meet.
Thank you. Based on that information, I do find that Ms. Potter qualifies for the services of public defender, so the Washoe County Public Defender's Office will be appointed to represent her. And just to confirm that you are in the position where you can waive her appearance for today's proceeding.
Yes, Your Honor.
Thank you. We'll go ahead and proceed. We're here today for first appearance bail hearing. Probable cause has been found. Public Defender's Office has now been appointed to represent her. I am in receipt of the Nevada pretrial risk assessment, which indicates that she scored as a 10 or a higher risk utilizing that tool. State, are we ready to proceed with the bail hearing?
Yes, thank you, Your Honor. I believe Ms. Potter was the inmate that we saw being removed from the courtroom earlier this morning. So she scores a 10 on the risk assessment with 2 points for violent criminal convictions and 2 points for misdemeanor convictions. We were able to get in touch with one of the victims this morning, that being Miss Dawn Miller. She said she would certainly like a no contact order. She is concerned for her safety. She said that the defendant did try to hit and kick her a few days ago when the defendant entered her apartment. So as far as criminal history, she's got misdemeanor convictions from August this year, 2 counts of battery. She has 90 days suspended on that case. She failed to appear for her November 6th review hearing. No bench warrant issued, but the court did set an order to show cause for December 4th. She's got a misdemeanor conviction earlier this year in April for destruction of property. 2024, she's got misdemeanor conviction for destruction of or disturbing the peace, misdemeanor conviction for battery and resisting out of Sparks Justice Court, separate misdemeanor conviction for battery out of Sparks Justice Court, a misdemeanor conviction for trespassing, a citation for assault. That was out of this court. She was ultimately found incompetent early last year. 2023, another misdemeanor conviction for battery. She got a gross misdemeanor arrest for indecent or obscene exposure out of Elko in 2022. It looks like she had deferred adjudication in that case. A misdemeanor conviction for assault out of Oregon in 2020. Felony arrest for battery by a prisoner out of Elko with no disposition. Felony conviction for assault with a deadly weapon back in 2010. So Miss Potter has a very lengthy history of violence spanning decades, including very recent convictions for battery, 2 counts of battery, numerous battery convictions throughout her history, including multiple this year, last year, and the year before. And this case involves allegations of violence against a child, as well as a couple of other adults. And so she is definitely a high risk of continued criminal conduct. She's a danger to the community, so the state's requesting bail in the amount of $10,000, DAS supervision, no contact with Dawn Miller, Sarah Trumpauer, and Jose Luis Flores.
Thank you. Defense, just to confirm, are we able to proceed here today? Or are you requesting an interim bail?
Your Honor, we were going to request an interim bail. We were going to, based on the history in 2024 and the fact that Ms. Rains, who does competency courts, and I are both here today, and the contact in the room, asked that if we were appointed, we stay the case so that we could proceed on an SB 89. And I'm prepared to make that orally if you'd like, or by writing.
Thank you. So I believe it is the defense, the public defender's office who's requesting to not go forward on an SB 89 request until a criminal complaint has been filed. And so I just want to make sure that is clear, because if you are going forward, I do need you to provide a declaration.
Thank you, Your Honor. Your Honor, I wasn't sure based on what the state indicated whether there had been a criminal complaint filed. I apologize. We would ask for interim bail and anticipate filing an SB 89.
Thank you. The court will be setting bail amount of $10,000. Will be bondable with a 10% cash option and will be an interim bail amount. If the defendant is able to post that bail amount, I will require that she be supervised by the Department of Alternative Sentencing and must check in with DAS within 24 hours release. I am imposing the condition that she cannot possess any firearms or weapons, as this is alleged crime of violence. And I am imposing a no contact order where the defendant must stay 100 feet away from the named victims. And that will include Sarah Trum, Vivian Porter, and the minor child with the initials as previously discussed. So that will be the order of the court, and we'll go ahead and set a 72-hour hearing, which will be set for November 18th at 9:30 a.m.
And Your Honor, just to be clear, this is a Category B child abuse with a human victim. We're giving her the 10% option on that.
With the understanding at this point that you're going forward on a category B felony, yes, so just to make sure that is very clear if that is at this point, but will be imposed, and if that is modified, then this order should be changed. Thank you.
So she does have
With no 10% cash option. Susan Tyrell, followed by Martin Yoskovich.
Your Honor, Ms. Tyrell also had to be excused from medical reasons. We are prepared to proceed without her being present. We will be asking that it be set interim based on interaction with Ms. Tyrell as well.
Thank you. Do you have any information indicating that she qualifies for the services of public defender, as the public defender's office has not been appointed to represent her?
Yes, Your Honor, our information is that it appears based on the probable cause sheet that she was unhoused at this time. Her appearance, not that it matters, but just as anecdotal indicia is consistent with that. She has been 13 years in the area with no job and no one to call, and statements of being unhoused, and that is consistent with the NPRA based on the totality of those facts and that it was substantiated by her conduct during intake. I would ask that we be appointed as there's no job, no ability to make income, and no previous income that we could substantiate.
Thank you. I do find that the defendant qualifies for the services of the public defender, so the Washington County Public Defender's Office will be appointed to represent Ms. Tyrell. We are here today for a first appearance bail hearing. Probable cause has been found. The public defender's office has now been appointed to represent her. We will go ahead and waive her appearance for today's proceeding. And state, are you ready to proceed for an interim bail?
Yes, thank you, Your Honor. The state's requesting $30,000 interim bail, bondable only, DAS with testing for controlled substances, no contact with Kara Pedroni and George Kelso, and 729 East 2nd Street. If Your Honor wants some more information, basically she's got multiple convictions already this year, suspended sentence out of Reno Municipal Court. She has 12 failures to appear out of Reno Municipal Court since 2022 alone, and at least 3 additional failures to appear since 2022 out of Sparks Municipal Court. So she's obviously a very high risk of future non-appearance and future criminal conduct, so the state's requesting the $30,000 bail.
Do you have any information as to why testing is appropriate?
Yes, so she's got a misdemeanor conviction for possession of drug paraphernalia out of Reno Municipal Court already this year. That's one of the cases for which she has a suspended sentence.
Thank you. I'm setting bail amount of $30,000 bondable with no 10% cash option. It will be an interim bail amount. I will require that she be supervised by the Department of Alternative Sentencing, and she must check in with DAS within 24 hours of release. I'm not imposing the testing conditions. I don't find that that's sufficient at this time. Just to make sure that's clear of for the state of when we have a bail hearing about this, you're more than welcome to continue to provide that information to see if that is appropriate. Additionally, I am imposing the condition that she have no contact with the named address or the named victims in this case. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, which will be set for November 18th at 9:30 a.m. Thank you. Martin Yoskovich, followed by Robert Stover.
Your Honor, I am again solo today. Mr. Yoskovich did waive his appearance. This is an additional booking, and so we're prepared to proceed, but if we're not appointed yet, this is an additional booking. He is unhoused, and
So you don't, he's already been appointed, the public defender.
Thanks, Your Honor.
Thank you. We're here today for a first appearance bail hearing. Probable cause has been found, and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which indicates that he's scored as a 9 or a higher risk utilizing that tool. We'll waive his appearance for today's proceeding. State, are you ready to proceed?
Yes, Your Honor, the state's requesting $5,000 bail with DAS supervision if he's able to post. As Your Honor noted, he scores a 9 on the risk assessment. He's got 1 point for failures to appear, 1 point for felony convictions, 1 point for misdemeanor convictions. He's in custody, also on the trespassing charge out of Sparks Municipal Court. He's on lifetime supervision for attempted lewdness with a minor. He's got a failure to appear arrest in 2024, failure to comply conviction in 2020, DUI conviction in 2018. He's got parole violation arrests out of Montana in 2016 and 2017, a felony arrest for violating conditions of sex offender lifetime supervision out of Henderson in 2012 with no disposition, misdemeanor conviction for domestic battery in 2006, and a felony conviction for that attempted lewdness with a child. So Mr. Yoskovich has a lengthy history of non-compliance. He is in custody, as I mentioned, on the trespassing charge out of Sparks Municipal Court. He has that failure to appear in 2024, so the state's requesting $5,000 bail with DAS supervision if he's able to post.
Thank you. Defense?
Thank you, Your Honor. I believe that any monetary bail is going to be a de facto hold on this client. I don't think that under the facts as alleged in the PC sheet, Mr. Yoskovich should be held on what amounts to a no bail hold. Looking at the original Sparks Municipal, it is a trespass in this case. It appears that there was an issue in a cell. There was claim that it was mutual, if not defensive in nature. Your Honor, I believe that he can be placed out in the community safely. Even with that prior criminal history, he scores a 9. I believe that the less restrictive means are some oversight and potentially anger management or community support proof. He is unhoused and has actually asked for help with resources. So providing to DAS a document that he has reached out to either Hopes or the shelter or even the Liberty Men's Group in town, any of that to just show that he's trying to better his circumstances is a better protection for our community, accurately reflects his risk score, and is the least restrictive, most appropriate means. On that, I'd submit.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the appearance of the defendant. I will note the failure to appear as well as the lack of ties to this community. Additionally, I will note the criminal history as discussed. And so with that in mind, the bail will be set in the amount of $1,000 that is bondable with no 10% cash option. If the defendant is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing and must check in with the DAS within 24 hours of release. We will go ahead and set a 72-hour hearing, which will be set for November 18th at 9:30 a.m. Thank you. Robert Stover, followed by Julian Morales. Good morning. We're here today for first appearance bail hearing. Probable cause has been found that the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that he's scored as an 8 or a moderate risk utilizing that tool. Just to confirm, are we ready to proceed now or should this case be trailed?
Your Honor, I'm prepared to proceed. I believe that the failure to register is sufficient, and if the court will allow and the state will allow, I can recognize that that failure to appear stems from a felony and that there are other previous failures to appear. I believe that the most recent one was 2019, but I believe that we can proceed today if the court wants to trail or if the state would object to the generalized indication of the criminal history, then let's trail.
I won't get into the details of the criminal history, Ms. Meyer.
Thank you.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found. The public defender's office has been appointed to represent the defendant. I am in receipt of the Nevada pretrial risk assessment, which indicates that he scored as an 8 or moderate risk utilizing that tool. State, are we ready to proceed with bail hearing?
Yes, Your Honor. So yes, Mr. Stover scores an 8 on the risk assessment. He's got a misdemeanor conviction from 2024 for possession of drug paraphernalia. He was also arrested for the same failure to a registered charge at that time, but that charge wasn't filed. 2023, he's got a felony arrest for possession of a forged instrument out of Lyon County with no disposition. He's got a felony arrest from 2023 for failure to appear on a felony charge with no disposition. He's got a misdemeanor conviction for the same thing as this case, but it's a misdemeanor out of California in 2019, a felony conviction for burglary out of California in 2019. It looks like he had a probation violation in 2022, and he was extradited to California on a felony warrant from Washoe County. 2011, he's got a misdemeanor arrest for failure to appear out of California. 2015, he's got that underlying gross misdemeanor conviction, a misdemeanor conviction for petty larceny back in 2009, and then it looks like some older drug convictions, misdemeanors back in 97 and 98. So really the big challenge for Mr. Stover is, I mean, he was warned by the police to register back in October, and he certainly knew that he needed to do so after he was arrested for this back in 2024, and he just continues not to register. And his own mother actually took him to the police department. So the state is requesting $10,000 bail, DAS supervision if he's able to post, and a requirement that he register within 24 hours of release.
Thank you. Defense?
Thank you, Your Honor. I think the last point is sort of our best argument for him being released on his own recognizance with the other conditions elicited by the state. Mr. Stover presents 3 points for residency and cell phone. We were able to speak with his mother, Miss Bonita, who did in fact bring him in based on the concern of failure to register. Miss Bonita now needs her son present in her home. She will be put on hospice, is my understanding. By the end of the week, they're waiting for a little bit more paperwork. He will be staying with her in Dayton. She has confirmed that. She has confirmed that he could register there. It would be expected as a part of him staying there, and that that condition and the medical reality that Mr. Stover is going to lose his mother soon is the change in circumstance, based on the fact that with that residency and cell phone number, we then move from an 8, which is where it is at now, to a 5. I would ask this court to release him on all of the conditions minus the monetary bail, as there are least restrictive, more appropriate means, especially in light of who he would be living with and the conduct as alleged in the PC sheet.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment, and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community and the appearance of the defendant. I will just note for the record that even with the lower Nevada pretrial risk assessment, the conduct is described with the history of non-compliance, and then the history of non-compliance within this case in terms of the attempt as discussed, and even the defendant's own statements, and then with turning himself in. I'll just note that for the record, and with all that in mind, the court will set bail amount of $5,000 bondable with a 10% cash option. I do find that given all the facts and circumstances, that is the appropriate bail amount in this case, and if he is able to post that bail amount, he will be required to be supervised by the Department of Alternative Sentencing and must check in within 24 hours of release. I am imposing the condition that he must immediately register within 24 hours of release, and that is due to community safety. That will be the order of the court. And we will go ahead and set a 72-hour hearing, which will be set for November 18th at 9:30 a.m. Thank you. Julian Morales, followed by Jason Murley.
I'm sorry, Your Honor, can you repeat the name again?
Julian Morales.
Thank you. Mr. Morales, I believe, is not here. He waived his appearance, Your Honor.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent him. I am in receipt of the Nevada pretrial risk assessment, which does indicate that he scores as a 6 or a moderate risk utilizing that tool. We will go ahead and waive his appearance for today's proceeding. State, are you ready to proceed with bail hearing?
Yes, Your Honor, the state's requesting $10,000 bail with DAS supervision if he's able to post. Mr. Morales has a parole hold. As far as criminal history, he was arrested October 15th of this year for sex offender failed to register. He was also arrested for the same thing, sex offender failed to register, back in March, but we did not file charges on that case. Other than that, he's got his 2005 felony conviction for sex assault, 2 counts, and battery with a deadly weapon out of 8th Judicial District Court. It appears that he was released on that case in September of 2024. So that explains why he doesn't have criminal history until 2025. So, Your Honor, based on all of that, the state's requesting the $10,000 bail with DAS supervision if he's able to post.
Thank you, defense.
Thank you, Your Honor. Your Honor, based on the statute, I believe that the state does have clear and convincing evidence. There is no amount of monetary bail he can make, and with the presence of that other hold, I think all argument seems moot, but he'd like to be OR.
Thank you. Based on the Facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498. The court does find that the state has met its burden by proving by clear and convincing evidence that bail is necessary in this case in order to ensure the safety of the community. I will note just for the record and incorporate into my findings the facts and statements from the state. We will go ahead and set bail in the amount of $5,000 that will be bondable with no 10% cash option based off of the nature of the charges. And I will require that the defendant be supervised by the Department of Alternative Sentencing, where he must check in within 24 hours of release. We will go ahead and set a 72-hour hearing, which will be set for November 18th at 9:30 a.m. Thank you. Houston Morley, followed by Huey Stanley. Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a 3 or low risk utilizing that tool. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state's not objecting to an unrecognizance release with DAS supervision.
Thank you.
No objection, Your Honor.
Defense? Thank you. I do find that that is the least restrictive means in order to ensure the safety of the community and your parent sister. You will be granted an unrecognizance release here today. You will be required to be supervised by the Department of Alternative Sentencing. I am imposing the condition that you cannot possess any firearms or weapons based off of this charge. I do find that that is a least restrictive means in order to ensure the safety of the community. So that will be the order to court, and we will go ahead and set an arraignment, which will be set for November 26th. At 9 a.m. We'll see you back here in court on that date and time. Thank you.
Court's indulgence, just one moment. Thank you, Your Honor.
Thank you. Huey Stanley, followed by Melody Allen. Good morning. We're here today for two separate matters. Just for the record, probable cause has been found. The public defender's office has been appointed to represent you in both of those cases. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as an 8, which was overridden to a higher risk. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state's not objecting to an unrecognizance release on both cases with DAS supervision with testing for drugs and alcohol.
Thank you. Defense?
No objection, Your Honor.
Thank you. I do find that those are least restrictive means in order to ensure the safety of the community. So, sir, in both of these matters, you will be released on your own recognizance. I am requiring that you be supervised by the Department of Alternative Sentencing, so you must check in with the DAS within 24 hours of release. I am imposing the condition that you cannot use any controlled substances or alcohol unless you have a valid prescription and be subjected to random drug and alcohol testing. I do find that there's a sufficient nexus based on the allegations as well as with the NPRA score. So that will be the order of the court. So just to make sure it's clear, is you cannot use any controlled substances or alcohol unless you have a valid prescription. And we will go ahead and set your arraignment, which will be set for November 26th at 9 a.m. So we'll see you back here in Reno Justice Court on that date and time. Thank you. Melody Allen, followed by Alyssa Bailey.
Miss Allen is not going to appear, and we're prepared to proceed without her.
Thank you. We're here today for first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent her. I am in receipt of the Nevada pretrial risk assessment, which indicates that she scored as a 9 or a higher risk utilizing that tool. We will go ahead and waive her appearance for today's proceeding. State, are you ready to proceed with the bail hearing?
Yes, Your Honor. The state's requesting bail in the amount of $3,000, DAS supervision with testing for drugs and alcohol. So she scores a 9 on the risk assessment. She was scored 1 point for failure to appear, 2 points for violent criminal convictions, and 2 points for misdemeanor convictions. She's got convictions already this year, 2 separate ones for trespassing. One of those she does have a 25-day suspended sentence on. 2024, she's got misdemeanor convictions for trespassing. She's got a misdemeanor conviction for tampering with a failure to appear, misdemeanor conviction for camping on public property. 2023, she's got a misdemeanor conviction for battery with her suspended sentence revoked in that case. Misdemeanor conviction for removal of a shopping cart with a failure to appear. Her suspended sentence was revoked on that case. And then another misdemeanor conviction for trespassing. In 2022, she's got a battery conviction with the failure to appear, misdemeanor convictions for disturbing the peace, trespassing, and obstructing with 6 failures to appear on that case. She's got numerous other misdemeanor convictions, including a domestic battery in 2018, with a lot of failures to appear throughout her history. So based on her risk of future non-appearance, and continued criminal conduct, the state is requesting bail in the amount of $3,000. And I requested testing, but I'll withdraw that request, Your Honor.
Thank you.
Thank you, Your Honor. Your Honor, it's cases like these that make me deeply aware that Park Boulevard is the largest mental health treatment provider and homelessness shelter in Northern Nevada. It is crippling to me that there is a $3,000 bail set, as the dangerousness to the community seems to be because she can't find housing and gets swept out of her encampments. That said, I understand that this court will look at her failures to appear. I still believe that this is an OR case, but I understand the nature of her compliance is challenged by the very underlying facts of poverty that bring her in here. I don't think she's a risk to the community. Stealing shopping carts and staying on land that is unoccupied feels not at the nexus of criminal justice, but I'll submit to Your Honor.
Thank you. Do you have any argument as to what would be appropriate least restrictive means?
DAS with daily check-ins at the shelter. I mean, I recognize, Your Honor, and I know that it's 10/12 on a holiday, but I recognize that the challenge for this court is imposing some sanction short of incarceration to deal with the challenges of poverty and being unhoused and potentially mentally ill. I don't know. If I knew, Your Honor, I'd run for some form of office, but I just know that monetary bail is not at the nexus of what we mean when we look at the 14th Amendment. And so I struggle not to say something.
Thank you, and I do appreciate that. And just for the record, I did indicate that the defendant had been appointed to the public defender's office. However, she did not provide the sufficient paperwork. Given all the facts and circumstances, I am appointing the Washington County Public Defender's Office to represent her at this time. Just for the record, I will just note that if community court was still available here today, that would be the order of the court to have her be directly transported to community court tomorrow with a release order to community court. Unfortunately, that is not an option. And so the court is struggling with the information as provided in terms of if there are any least restrictive means. And at this point, I do not have any least restrictive means that can be imposed in order to ensure the safety of the community. I will note that if there's additional information provided regarding whether or not she qualifies for therapeutic court services, that could be considered. But at this time, I do not have any information that we have sufficient means that can be imposed in order to ensure the safety of the community, just with respect to her failure to appear, as well as with the compliance issues as discussed. I do find that bail in the amount of $3,000 with a 10% cash option is appropriate. I will require that she be supervised by the Department of Alternative Sentencing, and so she must check in with DAS within 24 hours of release. That will be the order of the court, and we'll go ahead and set a 72-hour hearing, and that will be set for November 18th at 9:30 a.m. Thank you. Alyssa Bailey.
Hello.
Good morning. We're here today for a first appearance bail hearing. Probable cause has been found and the public defender's office has been appointed to represent you. I am in receipt of the Nevada pretrial risk assessment, which indicates that you scored as a moderate risk. It's not pulling up, my apologies. Give me just one moment.
Sorry, yeah, I was gonna just say I already went to court for this. Oh,
I'm gonna have you hold on one moment. Give me just one moment. No worries. I got it, we're good. Thank you. And I am in receipt of that Nevada pretrial risk assessment as I indicated, which indicates that she scored as a 7 or moderate risk utilizing that tool. State, are we ready to proceed with bail hearing?
Yes, thank you, Your Honor. So Ms. Bailey, she scores a 7 on the risk assessment with 1 point for failures to appear, 1 point for misdemeanor convictions, and active suspended sentences on 2 Reno Municipal Court cases. All of her criminal history is from this year. She's got a misdemeanor conviction for petty larceny from October 13th. She's got a 30-day suspended sentence in that case. She's got a misdemeanor conviction for resisting from October 21st. Out of Reno Municipal Court, she never checked in for pretrial supervision in that case. A battery charge was dismissed as part of the negotiations. Her mother, the victim in this case, was the victim in that case as well. She's got a misdemeanor conviction for disorderly conduct out of Reno Municipal Court. She never checked in for pretrial supervision, and then she failed to appear for her bench trial. So unfortunately, Miss Bailey is just not going to comply with court conditions. She was ordered to have no contact with her parents or their residents, and she climbed into their house through the dog door. So there are really no least restrictive means that this court could impose to ensure the safety of the community, particularly the victims in this case, and her future appearance in court. So the state is requesting bail in the amount of $10,000, DAS supervision, no contact with the victims, Scott and Christina Bailey, and their residents. And I would note also, Your Honor, we did get in touch with Mrs. Bailey this morning, and she, of course, does want the no contact order.
Thank you. Defense?
Thank you, Your Honor. Your Honor, I believe that in this case, there is a least restrictive. I believe DAS supervision. I know the history of the failures to appear. Ms. Bailey says she learned her lesson. She's got a place to stay with a friend. We were unable to reach them this morning because of the inability to access that phone number. So what I would ask is that she provide to DAS that address within 24 hours, and then additionally provide indication that she has either reached out to HOPE or the Empowerment Center or another place for an evaluation within 72 hours of release. When I look at someone who has no criminal history until the age of 27, experientially and anecdotally, though I'm not an expert, that suggests that is consistent with the timing of some appearances of mental health conditions that did not previously appear. Given the totality of the circumstances in this case that the TPO had been served that day, she did go back to that home. She, I believe, now fully understands what is at stake. I believe it was her legs locking in terms of the obstructing and resisting. Given the totality, we would ask that this court find that it's not clear and convincing that something less like daily check-ins with that proof of compliance with seeking services is not sufficient for community safety and appearance at court.
Thank you. Based on the facts as presented, the Nevada pretrial risk assessment and the factors as outlined in NRS 178.4853 and NRS 178.498, the court does find that the state has met its burden by clear and convincing evidence that bail is necessary in this case. I will just note for the record, the criminal history is discussed in terms of the history of non-compliance, the history involving the same victim, and the failure to appear, as well as with the aggravated facts and circumstances as discussed in the declaration supplement in terms of that she had just been served with the TPO and the likelihood of conviction. In this case, I do find that the state has met its burden. And I'll just note that I have considered least restrictive means, and I don't have information to be able to determine at this time that there are any least restrictive means that can be imposed in order to ensure the safety of the community. Bail will be set in the amount of $5,000 that will be bondable with a 10% cash option. If the defendant is able to post that bail amount, you will be required to be supervised by the Department of Alternative Sentencing, and you must check in with DAS within 24 hours of release. I am imposing a no contact order with the named victims in this case, and so you cannot contact or unless stay 100 feet away from them. You cannot contact or attempt to contact them in any way, including in person, phone, text, email, electronic means, or through social media, either directly or through an agent. That means someone working on your behalf. Just to make sure it's clear that it's both Scott and Christina Bailey, as well as the address of 10656 Walton Park Drive. That will be the order of the court. And just to make sure that's very clear, that begins immediately. We will go ahead and set your 72-hour hearing. That'll be set for November 18th at 9:30 a.m. Thank you.
Thank you, Your Honor.
Thank you.
No, it's okay.
Thank you. And just want to confirm, according to my list, I believe that is everyone for today. Just want to make sure.
It is, Your Honor. Thank you.
Thank you, everyone. Have a great day.
Thanks, you too.
Happy Beth.